Good morning. Good afternoon, good evening, depending where you're joining us from. My name is Rad El Treki. I'm head of office and head of corporate for Al Tamimi in Bahrain. It's a pleasure to see so many of you joining us today for our webinar. A quick housekeeping item from my side. Look, as ever, we want to keep this as interactive as possible and to try and make sure that all of our attendees get the most out of it. Please do feel free to plug in your comments into the chat box at the bottom of the screen. And time permitting, then we'll try and address those questions at the end. Guys, if we cast our minds back to 2018 at Saudi Arabia's flagship investment conference, the Crown Prince Mohammed bin Salman took to the stage to promise that a new era was dawning in the Middle East. The new Europe is the Middle East, the Crown Prince confirmed, and the coming renaissance in the next 30 years will be the Middle East. The data supports this. Global growth continues to grow to slow while GCC economies continue to be resilient. Economic forecasters expect moderate global growth globally in 2024, whereas by contrast, GCC states are poised to effectively navigate a decelerating global economy with impressive GDP growth predicted for 2024. As Oxford Economics put it on the topic, they predict that the region will continue to outpace most advanced and emerging economies in 2024. Now, as a corporate lawyer, I'm always very interested in foreign direct investment and FDI. And it's clear that FDI plays a crucial role in economic growth, and that continued positive FDI in GCC states is going to be of huge importance to the continued growth of the region. Most literature supports the suggestion and the importance of the rule of law when it comes to attracting FDI investment and accordingly economic growth. Anecdotally, it's been stated that CEOs prefer countries that provide investment safety linked to adherence to the rule of law, upholding of private property rights, and use of an efficient and effective court system. Now, against that background, then, we've assembled a panel of speakers today from our various offices within Al Tamimi, and we're going to try and sort of pull back the curtain somewhat and explore some of the key developments, in particular in the dispute resolution space that's occurring in the MENA region. We're going to try and do that sort of from a macro perspective, like a bird's eye perspective, to give a high level overview of what's changed or what's changing in various jurisdictions. Again, with particular focus on the dispute resolution space. So some brief intros from my side. As to our panelists, we've got my colleague Naif Yahya, who is a partner in our Dubai dispute resolution practice, a highly ranked lawyer with particular experience in construction, commercial and banking related matters. My colleague Georgina Munich, who's in our DIFC office, England and Wales qualified, deep experience in high value commercial arbitration across the MENA region. My colleague Noor Reyes, who is a partner in our Bahrain practice, heads up the dispute resolution team here. Again, deep experience in dispute resolution, being litigation and arbitration. My colleague Roy Georgiadis from Qatar, a highly ranked lawyer in our Qatar office with deep experience across the full remit of dispute resolution matters. My partner Basma Al-Kayumi in our Oman office, England and Wales qualified and Oman qualified, and has represented clients in over 2,000 litigation cases, again covering the full remit of litigation. My colleague Dr. Ahmed Basrawi in our Jeddah office, with particular experience in advising Saudi government authorities when it comes to drafting, preparing and implementing new laws. And last but not least, I have my colleague Khalid Yusuf, England and Wales qualified and Egyptian qualified lawyer from our Kuwait office. Again, deep experience in particular in construction, IP, commercial agency, and real estate. So look, given the quotation that I mentioned from His Highness the Crown Prince Mohammed bin Salman, I feel it quite apt to start potentially now with Saudi Arabia. So Dr. Ahmed, look, I formerly and briefly practiced law in Saudi Arabia, and what I found to be one of the most challenging issues there was the absence of a sort of central codified civil law. I understand, there's been big change in this space in Saudi Arabia recently. Perhaps you can walk us through that and some of the other changes that have occurred in Saudi Arabia. Hello, Dr. Ahmed. You're on mute, sir. You're on mute.
Okay.
There
Hi.
you go.
Thank you, Rad, for your introduction, and thank you all for the attendance. And I think you are rightly start with vision of Prince Mohammed bin Salman when he was talking about reforming and developing our economy in the region. And he started with Saudi Arabia. And he announced at the beginning of 2022 that Saudi Arabia will have a major legal reforms. And that legal reforms in Saudi Arabia ask doing 4 laws, 4 principles, or 4 core laws in Saudi Arabia. They start to issue the family law, codified all the family matters, and law of evidence, and civil transaction law, and criminal law. They issued the family and the law of evidence at the beginning of the 2023, and at the end of the year they issued the law, the civil transactional law, and it get effect. The effective date is in December 2023, and now we have the backbone of our legal system is effective, and that law is very big and huge, 721 articles.
Wow.
It covers all the civil transactions and also is considered as a public policy of the contract laws, of the source of the obligations, and all unjust enrichment, all of those elements applied in the region. Bahrain, Qatar, originally came from Egypt, and the UAE as well. And now we have similarities in our laws that makes the investors in the area is more familiar with the Latin schools of law, and also it's not it's aligned with the Sharia principles. It's not quite new. It's already there, but now we make it more organized, more clear. We will avoid many contradictions in between the judgments. This is the first side, and the second side also is very important to know about the procedures in Saudi Arabia. As many aware that we are applying the electronic system in all our judicial procedures. That system is being upgraded and upgraded and upgraded continuously, and now is working very smoothly, and the people is more familiar with the systems. Most of the hearings is online. All the procedures and all the requests is through the portal.
Thank you, Dr. Ahmed. So, I mean, it's quite transformative then, I would say then, in terms of, I mean, this is the first time Saudi Arabia has had a central codified, effectively a civil law, as you mentioned, that covers, you know, the full remit of commercial transactions, right? And I think, as you mentioned, Dr. Ahmed, then in terms of sort of investor confidence, in particular, sort of, you know, foreign entities doing business in Saudi Arabia, this, I'm sure, gives great reassurance. I mean, it's frankly quite groundbreaking, right?
Yes.
Okay.
Yes. Yep.
And tell me, in terms of litigating actually in the courts now, you know, with reference to the new civil transactions law, you know, how is that going? What's the feeling there? Because again, it's so new. Although many of the principles that are in there, you know, from Sharia and so on already existed, in a codified, centralized sense now, we have this one body of law. How, you know, how's it going in terms of the due process in the courts and dealing with the judges in the litigation space with reference to the new law?
Yeah, it's very good question. You know, we have recent issues and the legal arguments between the practitioner in case A, because that new law or the civil transaction law state the new concept in the civil transactions, which is the time bar. You know, the time bar is in the civil transaction law is 10 years in general, and in some cases it's 5 years, and in some cases 1 year. This concept is a new. And there is a lot, you know, there is the main questions about, you know, when this effective, or this will be start the time bar start from the effective date of the law, or applied applied when the obligation is erased. This, you know, as you know, in general in law, it should be the law effective dates start the the time bar starts from the effective date of the law itself. However, that laws in the introduction said is applied in all the cases in the court. It's applied in all the cases. Even if any case doesn't have final judgment, that law will apply. We have contradictions. Some, first instance courts about, this law is applied to date or not to date. And now we are waiting, waiting the higher court, the Supreme Court to issue the interpretation for this controversial issue. In our opinion, as Al-Tamimi, the time bar should be applied from the date of from the effective date of the law.
Right.
However, we are waiting, that.
Very interesting, very interesting. I think, look, I certainly would suggest that, that there's so much on this topic that perhaps in the future now we can do, I think there's the case to do a standalone we could do another webinar that discusses this as these things develop. So thank you very much for those insights, Dr. Ahmed, and something I think we can revisit in more detail in the future. If we move across the water now to Dubai, Naif, look, I know there's so much going on in UAE, as always, always going very, very fast and ahead of the curve. There's the one change that I was aware of that, I would mention is the change in the bankruptcy framework in the UAE. I think, this is something which is always of interest from an investment perspective, moving away from the sort of historical stigma that gets attached to bankruptcy in the region. So perhaps you can walk us through that, Naif, and give us a whistle-stop tour of what else is new in the UAE.
Thank you very much, Rod, for the introduction. Good morning or good afternoon, everyone. First of all, let me just start my part by saying that the changes never stop. The legal frameworks in the region, it's changing every day, day by day. We're witnessing a lot of changes in the region. The competition doesn't stop. We talked about that in our last year's session, and especially between Saudi, Qatar, and UAE. The competition, it's really massive when it comes to legal reforms and also judicial reforms. We have seen the news in Saudi recently that they are going to introduce a new common law courts, for example. So that's part of the competition that we're witnessing in the region. In the UAE in particular, it never stops. It's tiring, to be honest, as a legal practitioner in the region. It is tiring, the changes that we're witnessing every year. So last year we started saying that we will slow down because there are a lot of changes already, but end of 2023 we've seen a lot of new changes, including, as you rightly said, Rod, the new bankruptcy law. And for the audience, just for the benefit of the audience, the new bankruptcy law, it's not about kind of regulating bankruptcy and restructuring procedures. It does contain very sensitive provisions that relates to dispute resolution in general, including the liability of directors. We have seen one of the most important change under the new bankruptcy law in the UAE that will be effective from May 2024, the introduction of the de facto directors or de facto managers liability under the new bankruptcy law. This is a very important change because in the past, under the bankruptcy regimes across different jurisdictions in the region, we couldn't catch the controlling shareholders. But under the new bankruptcy law, the shareholders have to have concern if they are controlling the management of companies, because if they have done any particular transactions without following the due process or corporate governance, and if the debts of the company or if the assets of the companies is not sufficient to repay the 20% of its debts, you may trigger your liability as a shareholder, not only the director. So that's a space we need to watch. Too many other changes in the bankruptcy law that will affect the dispute resolution mechanics in general. So that's a very important recent change that we have seen. I have chosen few trends that I would like to cover quickly. I know I have only 5 minutes, but I'll try to cover it as quickly as possible. The first trend we're seeing is that from now on, Saudi will start the sessions to cover all the recent trends in Saudi, because obviously Saudi is one of the most important market in the GCC. and we've all heard Dr. Ahmed talking about the massive reforms that's happening in Saudi. Joking aside, the first trend that I want to speak to you about today is the new civil procedures law. They have introduced special tribunals. So that's a game changer in local courts. In the past, we had common law courts, DIFC and ADGM, and also we had arbitration, obviously, that is available as one of the dispute resolution forum. But also now the civil procedures law introduced something called special tribunal, where you can litigate your disputes in local courts in English language. I think that the main takeaway of this is that the UAE law is trying to regularize what Abu Dhabi courts have already started to do a couple of years ago, or even more, when they have introduced the special tribunals, where you have American judges. They call them legal experts, but they are actually American judges to adjudicate the merits of disputes. And that is now clearly set out under Article 5 of the Civil Procedures Law. And it hasn't been really finalized yet because we're waiting for special resolutions from the head of the courts from Abu Dhabi or Dubai or any other court. So that's watch the space. You can litigate in local courts in English language very soon. The other trend that I have witnessed is that the judgment debtors or the courts in the UAE, especially in Dubai, they are taking a more lenient approach for judgment debtors, where it's not allowed anymore to have civil imprisonment of debtors. In the past, in the UAE, we used to have a very strong tool under the civil procedures law to ask the execution judge to impose civil imprisonment decisions against judgment debtors. But this is no longer available, according to a recent Dubai Court of Cassation General Circuit judgment. It's a game changer to my mind because it kind of affects the debt recovery cases, and you will not be able to put pressure on debtors, judgment debtors, to repay the debts or comply with judgments. It is still available if you, as a judgment creditor, manage to prove that the judgment debtor is dissipating his assets or he's financially capable of complying with the judgment. If you don't prove that, the judge will never give a civil imprisonment decision, which is a game changer in my mind. Another hot topic that I think is very relevant is the issue of the new central bank law, Article 121 of the new central bank law. That this topic needs a day in itself. So I'll just, from bird's eye perspective, as Rod said, this is a very important topic. Watch the space. There are things that are changing, conflicting judgments from Dubai, Ras Al Khaimah, and Abu Dhabi courts, but the position keep on changing day by day. And we are hearing some good news to banks that we might receive in the next few weeks. So I think keep an eye on the adequate security principle under Article 121 of the central bank law, and we'll make sure to update all our clients soon. Evidence law, it's another day that we need to talk about, but I think too many changes under the evidence law, including the change of production of documents. The mechanics of production of documents is much more easier than the old evidence law. Cross-examining experts has now been introduced. We have successfully managed to cross-examine one of the experts in Sharjah courts, for example, in one of our cases, which kind of helped us a lot in a court case, which is, I think, is a game changer, because you're trying to show the judge that the experts appointed by the court is not really familiar with the details, and therefore it helps you to win in litigation. So I think that's a game changer. Written witness statement is now permissible. It was not under the old law. So it's kind of changing things to common law perspective, where you can get a written witness statement from your witness, although you need permission from the court, but it's still a game changer in my mind. Introducing new evidence mechanics like electronic evidence, customary practice are very important change, in addition to the freedom to agree on evidence rules, any set of evidence rules, like the parties can now agree on IBA evidence rules, for example. So that's a very important change in my mind. The other thing, I know I'm running a bit.
No, it's a long,
Yeah.
it's a long list for Dubai, mashallah. No, so please tell me.
Yeah, let me stop there. Unless you have any other questions for me, then I'll try to catch up later in the questions.
Okay. I mean, look, that's very, very comprehensive, and you know, I'm tired, as you mentioned, Naif, just thinking about the volume of change there, right? You know, there's so much going on there. As ever, I think, you know, Dubai is going very, very fast. It's very comprehensive. You mentioned as well, obviously, that, you know, Saudi Arabia is now also, they're both going at breakneck speed in terms of, you know, either whether it's by sort of revolution or by evolution, you know, upgrading the full raft of legal processes, legal procedures, and you know, the dispute resolution landscape. So very positive. And I think, again, to come back to a point you made, and I think that Dr. Ahmed made, I think it would be very interesting as well to drill down in some specific webinars on sort of Saudi, and maybe not necessarily Saudi versus UAE, but we, you know, on those topics, because there's so much there. Those are topics in and of themselves. So thank you, Naif.
Thank you, Raj. Just one quick one. It's a game changer. To my mind, one of the most important game changer is recovery of cost, where local courts now, you're allowed to claim for costs, your attorney fees and legal cost. It's not yet in play, but we are waiting for executive regulations to regulate this issue. It is going to be a game changer, because first of all, it will affect the load of the caseload on judges, because not every morning we find the baseless claims in front of the judges. Right. Now the parties will be careful before filing cases in local courts. So I think that's a game changer that I wanted to note to the audience.
And in terms of, you know, are there sort of rules and guidelines out on that, Naif, in terms of how it will work and how it will play out in practice? Or
no, it's few articles under the new advocacy law that was enacted last year, but we're waiting for executive regulations. So watch the space.
Very interesting. Very interesting. Thank you, Naif. If we move over to you now, Georgina, sort of to bring in, you know, the DIFC aspect and maybe ADGM, if you can give us an update and let us know, you know, what we need to know.
Thanks, Rad. Yeah. As we all know, DIFC and ADGM are common law jurisdictions, and the DIFC especially has been known to be particularly friendly to parties looking to enforce foreign judgments and awards. ADGM less so, and so friendly that until the recent case of Sandra Holding, parties could come to the DIFC to obtain interim relief for foreign proceedings, even before those proceedings had been issued, and the DIFC would willingly provide them with those freezing injunctions on the basis that the DIFC court had jurisdiction to order interim injunctions in aid of foreign proceedings, even where there was no connection with the parties to the DIFC. We now have the case of Sandra Holding, which came in recently, and it overturns this position. And the Chief Justice stated in that RDC 2524, which is the rule that gives the position on how you are to bring a claim for interim relief, should not be read on its own, but rather in parallel and consistent with the gateways of Article 5 of the Judicial Authorities Law. Article 5 of the Judicial Authorities Law sets out when the DIFC court to first instance has exclusive jurisdiction over a matter. So now we see, as a result of Sandra Holding, that at least for the foreseeable future, the practical effect of this decision is that the DIFC court will only grant interim relief in support of foreign proceedings where the jurisdictional gateways pursuant to that Article 5 of the Judicial Authorities Law are triggered. And those gateways all require a level of connection with the DIFC jurisdiction, either to the parties to the substance of that dispute. So, for example, entities that are licensed within the DIFC or contracts that are performed with.
Hello, Georgina.
Now likely, yeah.
Sorry, I think I missed that last bit. I think it was just breaking up.
Okay. I was just saying that in relation to Article 5A of the Judicial Authorities Law, those gateways each require a level of connection between the
Okay.
parties and the dispute to the DIFC jurisdiction. So, for example, interim measures are likely now to only be granted in cases where the DIFC entity is for example, being sued in a foreign jurisdiction and a claimant wishes to get a freezing order over its assets pending a judgment, because then Article 5A would apply, because that DIFC entity would have that connection.
Right.
But whilst this changes the landscape of the DIFC in relation to those interim measures, with regard to access for any foreign proceedings, we do have to still be careful to differentiate between that interim measures access and the position that the DIFC has taken historically in relation to enforcement and how friendly it is in that regard. Foreign parties can, of course, still take advantage of the DIFC being a conduit jurisdiction, unlike ADGM, which is obviously only for ADGM enforcement alone.
Yep.
And that conduit jurisdiction gives us access to enforcement in the UAE onshore and across the GCC more widely. There are a couple of additional points to note that I'd like to touch on if we still have the time.
Please do, sure.
We've got a decision in the industrial group as well, which clarifies that sources of DIFC law must come from the DIFC. So legal principles and causes of action under English law, for example, that don't exist under the codified DIFC law can't be read into or imported into the DIFC law. So if the cause of action does not exist in DIFC law, foreign principles cannot then be relied on to import that into the law.
That's quite interesting, Georgina, because look, what I often get asked, by clients when, on the non-contentious side is, well, let's go with DIFC law in this contract because it's basically English law, and it's sort of almost assumed, I think, by a lot of lawyers, really, that essentially you can sort of transplant in English law concepts, and on the basis that the DIFC law is, broadly based on English law. It seems that that's not actually correct then, Georgina, right? Hello,
Sorry.
Georgina.
Hello.
You're back.
I'm back. I'm back.
Yeah. Okay.
I got the end of that. I think I've got the gist of that. So yes, it is obviously broadly based on English law, and the common law system is there, and much of the principles within English law are present in the DIFC law, but you're absolutely correct. Not everything is, and you can't just take that as read that whatever your dispute is going to be in relation to will fall within those parts of the law that are incorporated into DIFC law.
Thank you. Very interesting, because again, look, in wearing my corporate lawyer hat, look, when we're negotiating out contracts, one of the sticking point is always going to be governing law and jurisdiction. And typically, look, in my experience, when you've got an international party, and you've got a party based somewhere in the MENA region, usually what will be settled upon eventually is DIFC courts jurisdiction, DIFC law. Okay. And I think, a lot of parties, internationally and locally are comfortable with that. But that specific point there on the English law is very, very interesting. And I'm actually enlightened by that, because I think I was possibly even laboring on the assumption that we could transplant in any broader concept under English common law. So thank you very much, Georgina.
Just to add on that, it really does highlight the importance of making sure that your disputes and your governing law clauses are very well thought out at the beginning, and you can't just drop in any governing law or disputes clause that you want in there. It's important for people looking at that to look at what the dispute between the parties might be, and whether that dispute is likely to fall into the laws that you have added into your contracts.
Absolutely. No, absolutely. Thank you, Georgina. Okay, so moving, again, across the water again, or down the road, we're going to switch to my personal preference, which is Bahrain, obviously. So Noor, to sort of bring you in on this now, I know Naif was talking about, for example, that proceedings in onshore, Dubai courts potentially in the future would be, can be conducted in English. I understand, there's some similar changes in Bahrain as well. If you can sort of walk us through those and what else it is that we need to know about developments in Bahrain, please.
Thank you, Rad. And as you said, and Naif will say, there are some game changer decisions in the region, including KSA and and Dubai, and Bahrain is no exception actually. So basically, we had this significant development last year, whereby the new English court has been launched before the Bahrain Chamber for Dispute Resolution, which is a part of the judicial authority in Bahrain. And now we have special courts designated to fully function in English, where the contract is in English and the value of the case is over 500,000 Bahraini dinars. And there are so many reasons behind this, but mainly it was to cut costs, the translation, where where it is expected to be significant, considering the value of the case. Another reason has been also taken into consideration is to basically allow the non-Arabic speakers or non-Bahraini to oversee the proceedings before the courts in Bahrain. So basically, it's just providing a sort of more sophisticated litigation process, and probably that objective also is led to the other current bigger project of the Supreme Judicial Council to basically launch the new onshore courts in Bahrain based on the model of the Singapore commercial international courts. And the project is still in its early stages. It didn't see the light yet, but it is expected to be very competitive to the model we're seeing in DIFC and ADGM and so on. So it's very constructive in terms of the developments in Bahrain. We're seeing lots of changes coming into place to sort of enhance the legal dynamic in the Bahraini market. Add to that what has and I know this is one of the questions that has been raised within the chat box, the mean to enforce the GCC judgment or the foreign judgment generally, and that was one of the subjects was discussed during our last session.
Yeah.
And the answer was that it's very confusing. We don't usually know how to approach the court. It's either going to the court of execution and you end up being referred to the civil court, or vice versa. So now we know for sure that the mean to basically to enforce GCC judgment is to go to the civil courts based on the circular made by the Supreme Judicial Council, and this actually saved saved the time and the trouble of the claimant basically. So we know what to expect when we go to the court of the civil courts to enforce a GCC judgment, and it's a matter of formality. Usually, it doesn't take much time. It's just to ensure that everything in a place, and the execution court will not expect or encounter any obstacles when it comes to enforcing the judgment. So I think the developments are really positive in Bahrain. There are more developments expected to be coming this year and this upcoming year, including the construction or the building law, which is set to replace the 1977 law. And the courts in Bahrain actually plays a major role when it comes to introducing the new sort of principles or the similar models in other jurisdictions. So what we've been seeing for the past few years is that the court in Bahrain are taking more sort of liberal approach towards some legal taboos that we had back in the days, including, for instance, enforcing or obtaining a copy of the foreign law if it's required to be submitted by the claimant. So back in the days, if you failed to submit the foreign law, basically the court would be dismissing your case. Now there is a very recent decision made by the cassation court that the judge may not refrain from adjudicating on a dispute merely because there is the required foreign law is not submitted, and should alternatively rely on the rules of justice and equity. And this is, I think, it's a very significant change. That wouldn't be the approach of the court back in the days. It's written on stone. If you have to provide the law, you have to provide it. we've also seeing a new trend with we've been seeing new trend with the BCDR and the courts recently, where basically the arbitration clause would be extended to third parties, which wouldn't happen normally. And this will happen on the occasion where there is a group of contracts and they will be interconnected between themselves. So the court will try to find some room basically to extend the obligation to third parties where there is no agreement on arbitration clause. So that's in a nutshell. I think it's very positive and constructive. And as I said, we're expecting more changes to take place this year, inshallah.
Thank you, Noor. Yeah, and that is, again, that is very, very positive.
Yeah.
And I think, Bahrain continues to punch above its weight as it historically has done. Some very, very interesting points there. On enforcement, Naif, if I bring you in.
Yeah, I think just one point. I mean, I agree with Noor. We've covered this in much more detail in our last session, the enforcement, the choice of law, the enforcement of foreign judgments and arbitral awards. But nothing major has changed other than the fact that we have much more pro-arbitration vibe in the region. As Noor rightly said, in Bahrain, it's similar in the UAE and also KSA and other jurisdictions. I do agree. I mean, I've seen the question as well, and I do agree that there are a lot to be done in that area, but we're getting better. I mean, that's from my perspective. The choice of law point, it's still problematic that most of the GCC countries or most of the countries in the Middle East kind of don't respect the choice of law when it comes to commercial cases. But you have the choice. If you want to apply English law, you have the choice to go to agree on DFC and ADGM, for example. And soon you will have a common law court in Saudi. So I think we are getting better. We need to develop more. We are still seeing some negative decisions and judgments from UAE courts, but things are getting to the right direction, in my opinion.
I agree. I think everything that I'm hearing and everything I'm seeing is all extremely, extremely positive now. I entirely agree. Georgina, if I can just quickly bring you back in again, I think that you wanted to clarify a point on ADGM.
Yes, and it actually runs quite neatly off of what Naif was saying. Naif's just said, if you want to run English law, you can do DIFC or ADGM. And the point I was making earlier is that the English law is not directly imported into the DIFC proceedings. But I think it's important to clarify that it is into ADGM. Okay. Wholly imported, including cases as precedent.
Interesting. Okay, so it stands in contrast then to DIFC on that point then, essentially. So even if it's not codified there, nonetheless, it does carry over.
Exactly.
Very interesting. Thank you, Georgina. If we move now to another one of my favorite jurisdictions, I have no favorites, but Oman, if I can hand over to you now, Dr. Basma, if you can bring us, bring us up to date, what's going on in Oman and what do we need to know?
Thank you so much, Rad. I think similar to all the other GCC countries in the last couple of years, and particularly post-COVID, we've seen new significant changes in the Omani legal landscape. And I think those cover both procedural changes and also substantive changes. From the procedural aspect, a new law was introduced in 2020, issuing the law simplifying proceedings in certain disputes. This law basically changed the litigation process to shorten the appeal periods, introduce electronic service, electronic submissions, and also to introduce limited appeal rights in certain disputes. The purpose of the law is to speed up the process and to avoid adversely impacting the parties' rights because of the long time that is taken to resolve disputes. So I think we are still seeing the impact of this law and the challenges from it unfolding. Apart from that, we've also seen the new labor law being introduced in July. The new labor law also introduced significant changes, one of which is the redundancy procedure. Prior to this, there was no clear redundancy procedure. And I think post-COVID or during COVID, this became an issue. And so the new law tried to address this gap. So now we have a clear redundancy issue. We have termination process for economic reasons and hardship. The economic grounds for termination are clearly defined in the law. There is also a process for terminating employees for low performance, which was also an issue because there was some inconsistency in the court decisions in this respect as to what would amount to a fair and proper termination procedure in this regard. Another interesting change in the labor law basically pertains to immunization, leave, and employee benefits and rights under the law. Apart from the labor law, we also have an interesting change in the court's treatment of enforcement of foreign arbitral awards. Traditionally or historically speaking, to enforce a foreign arbitral award, you would do that under the civil and commercial procedures law, which is basically you'll be bringing almost like a claim, and then it would go to primary appeal and then supreme, and to recognize and enforce the foreign arbitral award. Now in recent decisions from the court, we've seen a departure from this position. Basically, now the recent decisions have been indicating that these arbitral awards should be treated under the Omani arbitration law in a similar procedural way as the local arbitral awards. And basically, they're basing this approach on Article 3 of the New York Convention that basically makes it a requirement for contracting states to refrain from imposing any substantially onerous procedural requirements on foreign arbitral awards. Now, whether this trend will continue or it will go back to the civil and commercial procedures law, we're still not sure. It remains to be seen, because some of these decisions are under review by the appeal court as we speak. So I think, so I think the coming days should be very, very interesting in this respect.
Very, very interesting indeed. Just sorry to cut you off there, Basma. It's, as some of the guys said, it's something we looked at in great detail previously, but that's a really, really key development. In my understanding, and if that does hold water and continue, it sort of brings then Oman in the enforcement of arbitration space in line broadly, I think, with probably the wider region, right? And all of the jurisdictions we have here today. Noor, for example, I know in Bahrain that's generally the position, right? With reference to the arbitration law, that, a foreign arbitral award would be enforced with reference to that law without examination of the merits, right?
Yeah, of course. And it's a very simple application to be submitted to the court. Usually it's a matter of one hearing. Once the ratification is granted, you can go directly to the court of execution to enforce the judgment. So the court will not consider the merits of the case, but rather ensure that everything is in order and there is no contradiction with the public order and policy.
Yeah. So it'd be very interesting to see how that progresses, Basma, in the coming weeks and months. Actually, you're saying that some of these things are under review. And again, look, I'm sure there'd be a lot of interest to see, in the future, maybe to discuss what the outcome of that is, because it's a very, very pivotal, change potentially, right?
Yeah, no, definitely. Exactly. As I said, I mean, we're waiting to see how this would pan out in the next few months. But I think there's also, while this may shorten and simplify the procedure for enforcing arbitral awards, there's also a question, okay, to what extent the law would apply, the Omani arbitration law would apply. I mean, with respect, for instance, to annulment process, would that be applicable as well? So it is still unclear.
Yeah, still various unknowns, I suppose, but it will be, as I said, very interesting to see how these things crystallize. I suppose, hopefully, one would hope, sooner rather than later, in terms of the guidance that comes out, whether it's by appeal or otherwise. Thank you very much, Basma. If I move now to Qatar, to my good friend Roy. Look, Roy, I know it's sports day today, and I think you've ducked away from a marathon to join us or something, so we really appreciate it. Tell us about what's going on in Qatar, Roy.
Yeah, thank you, Rad, and happy sport day for all our colleagues who's attending from Qatar. Actually, in the recently we have many development and changes in the legal system here in Qatar, but I choose like top 2 or 3 just to be covered in 5 minutes. The most important one actually is the new trade law, trade investment court. Sorry, it's indeed established in 2021 and get effective in 2022. But today, in beginning of 2024, we can't talk practically about the new investment court, because previously whatever has been said, it's theoretical information. But today we have judgment issued by the first instance appeal and cassation by the new investment court. It's indeed a big step, good news, I think, for the market, because the main issue was in the legal system previously was the time frame for any court case, civil case or commercial case. It used to take 2-3 years easily. So now I can say that you can file a case, first instance, appeal and cassation, and you can get the final judgment with less than 1 year,
Wow.
which is a huge development. You file, the claimant file the case, 30 days for the defendant to reply, then claimant 15 days to reply, then defendant 10 days to reply, and that's it. First hearing within 90 days, you should get a judgment. Paperless, everything important online, which is very good for the environment as well. There is a relatively new law called the address law. So now everyone in Qatar, they have official address by this new law. So you get the court summons and a notification by SMS or email. So it's faster from procedure point of view. Everything is online, portal, request, even hearings in the criminal, and now it's coming to the civil cases as well. Copy of the judgment, you can get it very quickly now in 2-3 days. Previously, it takes like 2-3 weeks to get copy of the judgment to file an appeal. The appeal time frame is also shorter. Now you have 15 days to file an appeal and 30 days to file a cassation. It used to be 30 and 60. A new thing that you can use now in the investment court is using the third-party report, that you can put it in your supporting document. I think this is something happened like a while ago in UAE, if Naif correct me if I'm wrong. But now in Qatar, they have the same trend that you can put a supporting third-party report, which is good. Sometimes, if the judge is happy with it, they may not appoint an official court expert and rely on this third-party expert. So this is in general the good news about it. The area that can be reconsidered, maybe sometimes it's very fast. And for the complicated cases, sometimes 1 week is not enough to reply to counter-claim, huge counter-claim with thousands of supporting documents, and you have to translate it into Arabic. So I think this area can be reconsidered when you have a really very complicated cases. That with this new investment court, we don't have the chance to meet the judges. Previously, in the regular court, we have the chance to meet them personally to discuss. Now everything is online, so there is no human communications. This 2 areas, maybe it can be reconsidered. In addition to the enforcement procedures, in the enforcement, now it's much better than before, faster, more efficient, but still it can be developed more. So this is from quickly procedures point of view. Also, there is very interesting law number 8, 2023, which is a judicial authority law. It's coming with a new concept or new spirit to the civil law system. In my opinion, it's coming from common law system, which is Article 9, establishing the General Assembly of the Court of Cassation, and this General Assembly can issue judgments, and these judgments are binding to all the lower courts, which is a new concept here in Qatar, to have official binding judgment by the General Assembly of the Court of Cassation, which is binding to the lower courts. So this is a big development in my opinion. And also Article 17 allowing officially e-hearings now. So it will be applied, I think, very soon. We have many judgments issued recently by the Court of Cassation in relation to the arbitration. In general, it's all of them like friendly, I would say, regarding the arbitration. One of them, as Noor said, applying the arbitration clause to a third party, like extending the arbitration clause to cover a third party, which is a new concept, but interesting. Also, when you don't have a clear arbitration institution name in the arbitration clause, like a mistake saying like Qatar Arbitration Center. There is nothing called Qatar Arbitration Center. How the court deal with this? They deal with it as ad hoc arbitration. So this is also a new judgment issued by the court. Also, when the arbitration clause, it's not mandatory for the parties to go to the arbitration, the Qatari courts say that the court should take the jurisdiction because there should not be a vague arbitration clause that it's optional to use it or not. So it should be mandatory to go to arbitration, that both parties choose to go to arbitration. If not, the court might take the jurisdiction. So yeah, this is the.
It's very comprehensive, Roy. Very comprehensive. Again, lots of change there. Lots of very positive developments. I mean, I practiced law in Qatar from 2010 to 2014, as you know, for a few years. It was 10 years ago, and what you're saying to me is really, night to day, basically, in terms of some of those changes. Really fundamental. And again, look, for me, and it comes back to what Naif said. There is in particular, I think, the focus on UAE, Saudi Arabia, and Qatar in terms of almost an arms race, basically, of overhauling the laws, legislation, making things clearer, making things quicker, making things more investor friendly. So very positive. Now, I know we said we would tackle the questions at the end, but I have noticed one here, and it's from a friend of ours, a very good close friend of mine, and Noor's Faris Nasrallah. Hi, Faris, and glad you could join us. Now, it's Qatar specific, so I'm going to bring it in now, if that's all right, Roy. The question is, have the QFC courts formally extended their jurisdiction to cover all free zones in Qatar? And if so, how do you see the impact of that change?
The QFC courts, yes, for the investment court, how I can say it practically, in the new investment court, if you have a free zone, the question about the free zone, correct?
Well, I guess, yeah. So it's whether, I suppose the other free zones other than QFC, right?
So if you have a free zone company wants to go and to file the case in front of the investment court will not accept to register the case. So they would say go to QFC. So practically, yes, now there is kind of cooperation between the entities here in Qatar that they are pushing the free zone entity to go to QFC court rather than the investment court.
And then if I wanted to litigate against a free zone entity, Roy, equally, I would be required effectively to litigate in the QFC courts, or? In
principle, yes, but I don't have precedence in principle, so I can double check this point about if there is any precedence. Yeah.
All right, thank you very much, Roy. Last but not least, we're going to move on to Kuwait. So hi, Khalid. If you can whiz us through. I know that I've heard there's been in particular changes regarding, the requirement to have a local agent or a local sponsor and so on in Kuwait, which is, made big headlines, understandably, and it's very historic. So take us through to what's going on in Kuwait, Khalid, if you can, please.
Of course. Thank you, Rad, and thank you for the introduction and for everyone attending this webinar. But before delving into this, I just want to say, after hearing from my colleagues, I think Kuwait has a lot actually to learn from the neighboring countries. As you said, Rad, it seems like some of the GCC countries are in an arms race of changes and developments in order to make it more in line with the global change in dispute resolution in general. So I think Kuwait also needs to get into that race. But I think we're starting to, for example, as you said, there has been the most recent and most trendy change in Kuwait, or in development in Kuwait now, is that some provisions in the tenders law which required any foreign business to bid for a public tender to have a local agent. So before they could not even bid for public tenders unless they have a local agent. This has now changed also. Having a local branch or a branch of a foreign business in Kuwait required a local agent, and this now changed. And I think this will have also its impact on litigation, because I could easily say that the relationship between the foreign business and the local agent in Kuwait was one of the most litigious. Like most of the contracts arising out of this relationships or in this relationships end up in litigation. So this will actually decrease the scope of litigation related to these kind of relationships. Another recent development, relatively recent, is the bankruptcy law. I mean, similar to the UAE, we have also a new bankruptcy law in Kuwait. And the changes are quite drastic, actually, because I mean, as Naif also said, we have new provisions related to the liability of the trustees, the bankruptcy trustees, of course, and the directors of the company, which were not included or as quite detailed as in the new law, especially because before, bankruptcy process in general was actually addressed only through provisions in the commercial law. We did not have a fully dedicated law to bankruptcy. It was just provisions. So now it is more detailed. It's more clear. But the process the bankruptcy process, as I said, changed drastically. Before, it was just a civil claim or a court case. Actually, you need to file a court case to claim bankruptcy of a company or a trader. But now it's completely different. It's an application to what is called a bankruptcy division. So now we have a bankruptcy division in the court. It's not a court case, it's an application. And why it's so different now, and it's so I think it's such a huge development, because a court case usually would go through the normal process of the 3 stages, and it would take a long time, like seriously a long time. Also, it was quite a norm that the court would definitely need to mandate experts in the case in order to decide on the financial status and position of the company in question. But right now, we have this division, and at the same time, we have a committee that is or is constituted of not judges, actually experts, like financial experts, in order to help the judges or the judges of the committee in deciding the bankruptcy. So the process completely changed, and right now the decisions also of this division, the bankruptcy division, can only be appealed one time before the Court of Appeal in Kuwait, and that judgment of the Court of Appeal would be a final judgment and cannot be appealed anymore, as compared to the previous. So I mean, now it is expected that it would take, and we've seen it actually in practice. I mean, it's quite recent, so we haven't seen a lot of applications for bankruptcy, but we've seen 1 or 2. They would normally take maybe a year or so. Yeah. But before that, being a normal court case, it would take actually years, quite years, especially that the Supreme Court decisions or just scheduling a hearing before the Supreme Court takes usually a long time in Kuwait. Also, one of the good things that we've seen in the new bankruptcy law is the introduction of some of the electronic means, which we do not usually see. Like, for example, I could see in the other jurisdictions in the region that they started introducing electronic means in normal court cases in litigation. However, this is still not quite I mean, prevalent in Kuwait, or it has not been introduced yet, but it was introduced in the bankruptcy process. So now the bankruptcy law allowed the bankruptcy division, which is constituted of judges, to have what they called in the law as e-data room, or a room for the creditors and for the bankruptcy trustees, for all of them to first of all communicate, and any notices that are I mean, published or announced on this room to the creditors is deemed as official notice. This is compared to before, which of course it was used to, or it was required that it has to be published in the Gazette or in a public newspaper. And you know that this, of course, would also result in a longer duration, a longer period of time. So there has been actually a lot of changes with the bankruptcy law, and it's quite promising. We've yet to see how it will end up in practice, and because some of the areas of the new law has not been examined yet in practice.
Yeah, thank you, Khaled. Listen, very, very interesting and very positive. I think, look, maybe in terms of quantity, maybe Kuwait hasn't had the raft of changes, but clearly in a qualitative basis, it seems that, the changes that have happened there are very, very positive and very, very impactful. And again, as we were saying with Basma on various points, it will be very interesting to see how those things now start to bear out and play out,
Exactly.
in the months and sort of years ahead. So thank you very much. To all of our attendees, look, we scheduled for an hour, okay, but if you guys are happy to stay, we're happy to try and address some of the questions that you guys have kindly plugged into the Q&A. We'll try and do as many of them as we can, and as I mentioned, I think at the beginning, if we don't get time to finish any of those, we will we'll try and get back to you by email. We'll make sure that the right lawyer here comes back on the right question. So in no particular order, look, Naif, you're always very popular on the Q&A, right? So I don't want people to take it personally, but I'll start with one for you, Naif, which is changes to the UAE evidence law are particularly interesting. Parts of the new law seem to show similarities to the KSA's evidence law. It's understood that the KSA law intends to supersede certain sections of the law of civil procedure and law of civil courts. However, gaps in the new law can be filled in by other laws and Sharia law. Are there any notable gaps in the UAE evidence law or otherwise sections which in your view may conflict with other UAE laws?
Yeah, thank you, Rod. I think that's a bit
it's a lengthy
difficult
one.
question. No, it's a difficult one and actually very technical.
Okay.
But it's a great question. I'll tell you why, because there are procedural aspects to the evidence law where I do think they are aligned with the civil procedures law and the other relevant law like commercial transactions law as well. So and from procedural perspective, I don't see a conflict. I mean, we haven't really done a very thorough exercise to kind of check everything, but I don't see any apparent conflict from procedural perspective. But from substantive perspective is right. There are conflicting positions under the new evidence law versus some other laws like the civil transactions law and the commercial transactions law. But ultimately, that's the law of evidence of the land, and therefore that's the laws that should be applicable when it comes to evaluating evidence, assessing the evidence presented by the parties to the courts or arbitral tribunal, unless, as I said, the law allows the parties to agree on any set of rules, including IBA. I haven't seen it in practice, obviously, but the reason of introducing the freedom of the parties to agree on any set of rules, I think, is because of the special tribunals purposes. So that's a very important area to watch, but it's a very good question. And my answer is procedurally, I don't see any conflict, but substantively, yes, there are certain conflicts, even with some Sharia principles in my view, but ultimately the courts in the UAE will apply the evidence law when it comes to evaluation of evidence.
Thank you, Naif. There's a question about bounced checks in Oman. There's been a change there, I believe. Basma, can you bring us up to date on that?
Yeah, sure, Rad. So basically, with the new penal code, previously there was a clear distinction between checks issued by individuals and checks issued by a corporate entity. Unfortunately, now with the new penal code, there was an article introduced to basically make the signatory of the check personally liable for the value of that check, even though he may be acting in his capacity as a representative of the corporate entity that he's working for. Like I said, this is significant because it undermines the concept of limited liability. In the same line with this as well, in terms of the procedural aspect of submitting a complaint, a bounce check complaint, there is also a conflicting approaches. Previously, an authorized signatory with unlimited financial authorization can submit the bounce check complaint. Unfortunately, now there's the public prosecution has adopted a different approach, insisting that basically only a shareholder, being an owner of, part of the company's capital, is authorized to bring that complaint. Again, this is undermining the concept of limited liability, because actually the shareholders are not representative of the corporate entity. It is the authorized signatory that is supposed to be the legally authorized individual to represent and bind the corporate entity. So those are two significant changes, and similar to what we were talking about, the enforcement of arbitral awards. Some of these decisions are under review in the courts, and we remain to see basically what's going to happen in this regard.
Thank you very much, Basma. We have another question. It's from an anonymous attendee. It's for you, Dr. Ahmed. Is it true that Saudi Arabia is currently working on a codification of choice of law rules? Do you know anything on that space?
You know, it's in Saudi Arabia, as you said, we are improving by evolution, not revolution. In Saudi Arabia, we have major legal reforms, and a lot of projects is under process. As mentioned by many of the media about the news, about the common law jurisdictions, about choice of laws, the new law. There is hundreds of projects to upgrade our legal system and the judicial system itself. And I didn't see the project yet, but I think there is something about it. Yeah, it's common sense to have something.
Yeah. Okay. Thank you. And I think we'll do one last one. It's a general one, so I'll open it up. It's a question from Majid Oghli. Is mediation a growing practice? So, what are we seeing in the mediation space, in across our jurisdictions, perhaps? And is it considered to be a successful or indeed a binding dispute resolution mechanism in the GCC? Anyone like to throw up their hand and take that one?
I can do that. I mean, if I may.
Thanks.
I mean, there are two questions from the audience on mediation. It's a very important area. It is evolving for sure, not only in the UAE, but across the region. We're seeing a lot of new mediation laws and even mediation centers. And so a lot of the arbitration centers are kind of encouraging mediation and introducing mediation rules as well. So I think it's a very important space to watch. But I do believe that we are not there yet when it comes to the culture. So we need to work on the culture in order to change. I mean, the culture in the Middle East is that once we have a dispute, we have to try and even meet for settlements just to pick on evidence. That's the culture that we are witnessing. Right. So we need to change the culture from the legal community in the first place in order to enhance the mediation and the chances of success of mediation in general, which is something we as a firm actually welcome, because it kind of save a lot of cost on litigation and arbitration specifically. So I would say that we are trying to encourage mediation. We are actively involved in mediation. We've actually introduced a new section within the dispute resolution department to take the mediation to the next level. But again, we need to work on the culture in the region, not only on the laws. So watch the space, but it's up and coming area that we have to watch.
If I can add to that, I think I agree entirely with what Naif was saying in relation to changing the mindset. I think at the moment, the mindset is to try and mediate and settle once we've got awards and judgments, right, and settle on that number. We need to move that to trying to do that before we have to go through the whole dispute process. Forward thinking for the region, the mediation center is being set up by DIFC, and ADGM has also launched an online dispute resolution center.
Thanks, Georgina. Look, I've always found it a bit curious because, look, to my mind, the Middle East region has historically a very long history and a rich history of mediation, whether it was done at the sort of, at the Majlis level, people brought together with, a fair broker in the middle to try and find an amicable settlement. So it's very interesting to hear that, Naif and Georgina, in terms of hopefully, a move, a cultural shift back, I think, to a mindset of mediation as a viable step pre-litigation, and coming back to what you said, Georgina, before, raising the cudgels and sort of, going to war and formalizing dispute resolution. Okay, well, I think, look, we'll wrap it up there. As I said, guys, any questions, we'll try and come back to those on email. It just remains for me to thank everyone who's attended today for being so generous with your time. My apologies insofar as we've gone over the 1 hour slot. Thank you to all of our panelists also. And just to reiterate really what I said on our last session, look, we are going to be rolling out more of these, okay? And look, in terms of where we take the discussion and the topics that we cover, guys, to all of our attendees who have kindly joined us today, please, guys, feel free to reach out to us. Any sort of particular recommendations, any particular suggestions, and it would be our pleasure then to try and put together additional webinars with content which is as relevant, to you, our clients and our guests, as possible. So again, thank you to our panelists for their kind time, and thank you very much indeed for everyone who's dialed in today for our webinar, and we'll see you on the next one.
Rod, just to say that I've seen like few questions on the new central bank law in the UAE.
Okay.
It needs a day. I'm not answering now. I know you wrapped it up, but please feel free to reach out. And we have made the couple of articles on this topic, and the upcoming news I cannot reveal now, but hopefully soon in the next couple of weeks. So feel free to reach out, and we'll be happy to chat to you about it. Thank you so much, everyone. Thank you, Rod.
Thanks, guys. Thank you very much.
Thank you.
Thank you.
Thank you very much.
And thank you,
Thank you
everyone.
very much.
Thank you.
Bye-bye.
Thank you. Bye-bye.